Good evening. This is Rahul Reddy. We're live here from Houston, Texas. Every Tuesday, we do bring in immigration updates. Along with me is my business partner, Rebecca Chen. Rebecca, what do we have today to discuss?
Yeah, so we have an update on the $100,000 H-1B fee proclamation that was issued almost exactly a month ago now, or went into effect almost exactly a month ago. USCIS yesterday on its website finally published some clarifications, so we'll discuss those and how it adds to our understanding of this fee and how it will be applied. Also, we'll discuss with the government shutdown continuing to drag on. Of course, people are getting more nervous about how to file an H-1B. It's clear that we can't do so without a certified LCA. And so people who may be going out of status because they can't file an LCA or get their certified LCA may be worried about going out of status. USCIS has stated that they will take into consideration the government shutdown for any late filings, but we'll discuss, whether we should rely on that USCIS statement or take other action to protect people's status in the meantime. We'll also discuss the B2 change of status option for laid off H-1B workers as a way to kind of de facto extend the 60-day grace period. If you are reaching the end of the 60-day grace period and don't have a job offer yet, what are your options? And we'll also discuss FDNS cracking down on H-1B wage levels. We've been seeing NOIDs, notices of intent to deny, and notices of intent to revoke for some cases where FDNS believes that the wage level in an LCA for an H-1B worker was not appropriate.
So, Rebecca, there are some clarifications that we got in the last week of September that if the person is outside the country and first time applying the H-1B, they are subject to the H-1B. They are subject to the $100,000. If they are within United States, they are changing the status in United States, they are not subject to the H-1B. So based on the USCIS press release, that seems to be very clear. So we are spot on that. There were some gray area that were not clear that they clarified here. So I'm going to ask some questions with regards to I want you to answer. So if I had an H-1B before and I had an I-140 before, and right now I am outside the country, if the company is filing a consular processing, is the $100,000 applicable right now?
Yes.
If I am in United States, I'm filing the H-1B after September 21st, and I'm changing from company A to company B after September 21st, and gets the approval within United States of the H-1B, which is an extension of the H-1B or change of employer. And if I go outside after the H-1B is approved, and if I go for stamping, is the $100,000 applicable to me?
No.
What if I have applied for the extension of the H-1B, but I left the country and my passport visa has already expired. I left the country, and if the H-1B is approved, can I go for visa stamping without paying the $100,000 fees?
Yes, you can.
I think so. Let me repeat again. So, if the H-1B is approved I'm in United States, applied for the change of employer, I left the country, and the H-1B is approved after I leave the country.
Oh, after you leave if you leave while the application is pending.
Right.
Then no, because you
meant to say $100,000 is applicable.
It could be, yes.
Yeah. Okay. So that's the reason I want to make clear. So the bottom line here is that if you are within United States and you are changing the employer, you are extending the H-1B, you are changing the status from F1 to H1, you're changing from H4 to H1, you're changing from L1 to H1B. While in United States, you get the H-1B approval with the I-94, And
Yeah.
later on, if you want to go for stamping, the $100,000 is not applicable.
That's
Even
right.
though you were here on H-1B for more than 6 years in United States, got an I-140 approval, now you decided to leave the country, you stay outside the country, and now a company wants to apply in the consular processing, you are still subject to the $100,000 fees right now. Okay, so
Yes.
that's the clarity that we have, is that those people who were on H-1B, if they leave the country, they want to come back, that $100,000 is applicable. And if somebody changes from F1 to H-1B, and after the change of status is approved, and after October 1st, means that's when they are, if they go outside the country, they are not subject to the H-1B, which is a good news for a lot of the student visa people in H-4, that after the H-1B is approved, they can go for stamping. Any other clarifications that came in this one?
Yeah, so the clarification was along the lines of what we kind of suspected or assumed, but it does help that they came out and clarified those points. So it seems to boil down to, at the time the I-129 petition is being filed with USCIS, what action is being requested on the I-129 form. If we're requesting a change of status, extension of status, or amendment of status, which you can only request those for someone who is physically in the US in valid status at the time, then the $100,000 fee does not apply. If we are checking on the I-129 form, notify the consulate, we're basically requesting consular processing in the I-129 form. That's when the $100,000 fee would be required, regardless of whether that beneficiary, whether this is their first time applying for an H-1B ever, or they have had H-1B, like Rahul said, for years before. It's a matter of whether they're physically in or out of the US at the time the I-129 petition is being filed with USCIS. And then the clarification also gave kind of the instructions for, I don't know if there are companies that are actually planning to submit this $100,000 fee for anyone, but they gave instructions on how to do that. It's through the pay.gov website. And then you attach kind of a receipt, sort of a proof of the payment to the petition that you send into USCIS. So you have to pay it before you file the petition. And then they also gave sort of the criteria for the exception requests, the exemptions that they hinted at in the proclamation. They said that in order to qualify for an exception, the employer has to show that the worker's presence in the U.S. is in the national interest, that no U.S. worker is available to fill this role, that the worker doesn't pose a security risk, and that requiring payment for that applicant would significantly undermine U.S. interests. And you make that request by sending an email to an email address that's listed in that clarification on the website. They did make a note that said that exceptions will be extraordinarily rare. So that's not very encouraging for how many exceptions they are planning to grant, but at least those are the criteria, and that's the way to apply for it if you decide to try to apply for it.
Let's move on to the next topic, Rebecca. Right now, there is a shutdown. Everybody knows that the Department of Labor is shut off, and you cannot file the H-1B because the Department of Labor, you can't get the LCA approved. Now, the USCIS website may be suggesting that you have the eligibility to apply the extraordinary circumstances, that if by any chance you fall out of status, can you apply for the H-1B extension? Can you apply for the H-1B transfer after you cross the 60 days? Can you apply the H-1B extension or transfer after your I-94 expires? It's called non-protunct. That means that you are out of status, and please excuse me for being out of status. Now, is it safe for people to do that at this point of time? Or do you suggest them to move to B2?
So if your I-94 is about to expire, or you are about to cross the 60-day grace period, even though the USCIS website seems to indicate we will take into account your inability to file your application timely due to the government shutdown, we will take that into consideration. We wouldn't recommend depending on that and just letting your I-94 expire without doing anything, or just crossing the 60-day grace period without doing anything. Our recommendation is to still file a B2 change of status application before you reach that I-94 deadline or the 60-day grace period deadline. The reason is, first of all, that nunc-pro-tunc provision, it's still discretionary. The USCIS statement doesn't say that we will definitely grant the extension of status without considering, considering it late in every situation. They just said they'll consider it as an extraordinary circumstance when reviewing the application. And so it still comes down to the discretion of the officer who's reviewing your case. And under the current administration, we don't think it's necessarily safe to just let your I-94 expire and depend on the discretion of an officer at some point in the future. Also, ICE has been already, even before the shutdown, ICE has been issuing notices to appear in immigration court, NTAs, to people who had their I-129 petition withdrawn by an H-1B employer because the employment ended, which that's not a problem. So people have already been getting NTAs even when they were still in status, even when they were still within their 60-day grace period, even when they had already transferred timely to a new employer. So that was a trend that we started seeing over the summer. So if ICE is already doing that for people who are still in status, we don't necessarily think it's safe to just file, do nothing, just based on a USCIS statement on their website. So our recommendation would still be to file a change of status before you cross any deadlines. And then when the government resumes operations and the LCA can be certified, it would be a matter of filing the change of status back from B2 to H-1B. Those have still been filed this year under the current administration. They are still being processed. Every once in a while, we see an RFE saying that the I-539 needs to be approved first, but it's not the majority of cases. So we still think it's safer to apply for a change of status to B2 rather than depend on the nunc-pro-tunc argument.
I strongly believe that non-pro-tunc is not a proper argument right now in the Trump administration because it is discretionary. And we have seen people who have been out of status and who have crossed the 60 days definitely getting the notice to appear when they are making the non-pro-tunc argument. Now, previously in Biden administration or even in Trump administration 1.0, we had this non-pro-tunc. That means that I went out of status because of not my mistake, because of somebody else's mistake, which was beyond my control. We were getting the non-pro-tunc cases getting approved, but we started seeing the notice to appear. That means that you will be going to the deportation proceedings. Right now, under these extraordinary circumstances, what you may be considering based on the recommendation of USCIS, if you file this application, you are sending an invitation to Immigration and Customs Enforcement. Hey, look, I am not in legal status. I declare under the penalty of perjury that I am not in legal status. And ICE is not going to keep quiet, guys, right now under the circumstance. There is a good chance that they will issue a notice to appear. I strongly recommend you do not wait. If you are falling out of status, if your I-94 is expiring, file a B2. You can file a B2 online. And if you are having the 60-day expiration, that means you lost the job and you are getting to the 60-day expiration, you can file a B2 online application and then stay legally in the United States. Even if you are not considering B2 as very seriously as much as you think of this one as an alternative thing. There's a plan B, just in case by any chance your H-1B gets denied. Think of this as a plan B. But I would say that this should be the plan A. But if you still trust the other lawyers or other people who are recommending, I don't know why they're not seeing the NTAs, that only we are seeing the NTAs when people are making the arguments of the non-pro-tunc. So we want that argument of B2 to be the main thing. And extraordinary circumstances may be the alternative, not the otherwise. So please be safe under the Trump administration right now. Question with regards to we have seen a lot of people who have lost a job, who have moved to B2. And if the B2 is approved until November 2025, and if you are not still getting the job, or if you're getting a job and you can't file the H-1B because of shutdown, what are the options? you have an option of converting into F1. You can file a F1 change of status to premium processing right now and get the F1 approved. That option is there. You can apply for the B2. It's a little bit risky option that because you have already filed the B2 before, now you're filing a B2 extension. But under the current circumstances, if you leave the country and you're going to go outside the country and then you're going to apply the H-1B, the $100,000 is applicable. And that means that you're not going to come back into this country. So definitely, we strongly recommend to apply B2 extension or F1 right now, rather than leaving the country. And once you leave the country, you want to get the H-1B. Previously, we used to say, yeah, you can go anytime. If your I-140 is approved, you can come anytime in the next 90 years. We have told that several times. Even, if you have used 2 years of the H-1B, if you have 4 years left, you can go to India. In the next 90 years, you can use the rest of the 4 years at any point of time and come back. We have told several hundreds of times. Is that true anymore? Well, technically it's true, but the $100,000 is applicable, so we don't recommend. So definitely leaving the country right now is not a good option. Applying the B2 extension is a better option. F1 you can consider into that too. Rebecca, any thoughts you have on that?
Yeah, if the $100,000 fee gets upheld, which there are legal challenges already to it. So, we'll need to see how the lawsuits play out. But because it is structured mainly as essentially an entry ban, the government's discretion is broadest to individuals who are outside the US. And so there is a possibility that the $100,000 fee could be upheld in court, since at this time it applies primarily to individuals outside the U.S. We've seen that before with the ban on travelers from majority Muslim countries under the first Trump administration. That was upheld, and so if this does get upheld, it does make it much more difficult, basically, to come back into the U.S. if you depart. So it can affect. It will primarily affect, of course, applicants in next year's lottery who are outside the U.S. I think the government officials have come out and said that that's kind of what it's mainly intended to apply to, is brand new applicants from outside the U.S. But the way it's worded, it will also affect people who are not able to maintain status within the U.S. for whatever reason and can't get a change or extension of status approved, or people who are maxing out of their 6-year H-1B. Whereas it used to be kind of an option if you're nearing your 6-year limit and your PERM isn't going to get approved in time, you could leave the country, wait outside the U.S. until the I-140 was approved, or the PERM reaches the 1-year processing time, and then your company could file the consular processing application to bring you back in. That, if this $100,000 fee gets upheld, then that won't really be an option anymore. It'll be more looking for like H4 or B2 or F1 as a change of status to remain in the U.S., like Rahul was saying.
Rebecca, FDNS, they're seeing a lot of H-1B's notice of intent to deny, notice of intent to revoke, which because of the wage level discrepancy. Let's say, for example, if the H-1B has been filed with wage level 1, when the FDNS inquires the end client says it requires 7 or 8 years experience for that particular position, and this guy is putting at wage level 1. What are the consequences of those things?
Yeah, so FDNS would first, do a visit or reach out to the end client to get that information, and then it could be months later before an actual NOID or NOIR is issued to the petitioner. At that point, the petitioner will need to be able to explain the discrepancy. So the problem is that a lot of times when FDNS officers reach out to employees of the end client employees sometimes think that they are being helpful by making the job sound, as complicated or high level as possible, probably, or they are giving the beneficiaries actual qualifications rather than what are the minimum requirements for the job, which is actually what the wage level should be based on, not necessarily this particular applicant's amount of education and experience, but what do the job duties require? So that's where some of the discrepancies can come in. So if there is an NOID or NOIR issued to the petitioner should go through and kind of explain those differences, make clear to USCIS what the actual minimum requirements are for the job, explain that, so-and-so that you spoke with at Visa or whoever the end client is, we're probably giving what they thought was the applicant's qualifications or background in response to the questions. So it will require kind of trying to clarify that, but also employers will need to, when you're filing LCAs for H-1B applications, be aware of what are the requirements for the job and make sure that you're matching it to the wage level that you're selecting at the LCA stage, especially if this is an extension for an existing employee or a transfer for an employee that has been on H-1B for, 3 or 4 years at that point. Wage level 1 is going to get a lot more scrutiny under the current administration because at this point that H-1B worker has been working full-time in the industry for 3 or 4 years, they're no longer really entry level. And so USCIS and FDNS are going to question that if they see discrepancies like that.
There are several questions that are coming on with regards to the $100,000 fees, whether it's been applicable or not. So let me answer those questions. Concurrently filed H-1B, that means that if you're working for one company and then you want to work for the second company, is the $100,000 fees applicable? The answer is no. Since you're within the United States, this $100,000 is not applicable. If person is changing the status from H4 to H-1B, is the $100,000 applicable? No, it's not applicable. Question came from F1 to H-1B. If you're changing within the United States from F1 to H-1B, is the $100,000 applicable? No. Question came from J1 to H-1B within the United States. Is the $100,000 applicable? Absolutely not. It's not applicable right now. If a person has moved from H-1B to B2 and from B2 to H-1B, if they are changing the status to H-1B back within the United States, is the $100,000 applicable? The answer is no, it's not applicable. There are a couple of questions that came in. Are physicians exempt from this $100,000 rule? There is nothing, no clarification on it that the physicians are exempt. If the physician is outside the country and they're applying for the H-1B right now, under the current conditions, you are subject to the $100,000 fees. If you want to apply for the waiver, as Rebecca has pointed out, you have to go to those points. And if you're eligible, you may be eligible, but it's going to be very tough to get it. Are nonprofit organizations exempt, nonprofit higher education organizations exempt from this $100,000 fees? Remember that the $100,000 fees is only applicable if the person is outside the country is applying through the consular processing. If they're changing the status, it's not applicable, whether it's a cap subject or cap exempt. So for those people, for example, if a university wants to get a professor from, let's say, for example, from Japan, previously they don't used to go into quota, is $100,000 fees applicable? Right now, based on the clarification given by the USCIS, it seems that the $100,000 is applicable for nonprofit higher education institution if they're bringing the people from outside the country. Got the questions, Rebecca?
Yeah, we also have a question from Sri on, he came in on an L-1B blanket visa and is asking if a change of status to H-1B requires the fee. It does not. So as long as you are here in valid L-1B status, your employer can apply for a change of status to H-1B for you without incurring the $100,000 fee. Also, another question about the fee. Can I use an H-1B visa stamp unexpired with a previous employer to re-enter the U.S.? Is it subject to the fee? It is not. So the clarification and the government's previous statements did sort of make clear that the $100,000 fee does not affect any valid previously issued visas. It does seem like the whole idea with this fee is they're planning for USCIS to be the one to assess the fee, which is why the pay.gov it's done before the I-129 petition is filed. They don't seem to be planning to have the consulates with the State Department evaluate whether this fee is applicable and collect it, or CBP. So any existing visas are still usable, but of course you need an I-797 approval notice with your current employer, which hopefully you already have from being filed within the U.S.
A question with regards to whether $1,000 reissuance of advance parole when people are re-entering. That's $1,000 is not applicable for the employment-based advance parole, guys. You're safe. You can travel. That $1,000 is not applicable for the advance parole issued under the employment-based.
We have another question of, does the fee apply to someone whose H-1B petition is approved but has not yet gotten the visa from the consulate and has never traveled to the U.S.? So in that case, it depends on whether the petition was filed prior to September 21st. If so, also the fee proclamation does not affect any I-129 petitions that have a receipt date prior to September 21st. So that situation should be fine. And also so I have a client in that exact situation. They were selected in the lottery this year, have never been in the U.S. Application got approved. They went for visa stamping last week and it got approved. So the petition was filed before September 21st. So they were able to still attend the visa appointment, get the visa without the fee applying, even though it's after September 21st when they're going for the consular appointment.
One interesting question that Rick has bought YouTube is asking that question. This is about the lawsuit for the $100,000 fees. If it comes in a way which is beneficial to the plaintiffs, that means that $100,000 the government does not have a right to impose. Will it only be applicable to the clients that were there, that were part of the litigation, or is it applicable to the nationwide? Since recently there is a judgment from the Supreme Court saying that nationwide injunctions cannot be granted for everybody except for the clients that were involved in. You have a right to some extent, but there is still something called class action suit, though. So let's assume that if this case comes in favorable, though, there'll be a lot of petitions filed at different district courts, and there may be a class action suit coming immediately, though. So we are expecting that it should be applicable nationwide the way we are thinking about it, but we'll have to see how the court is going to rule on that. What do you say, Rebecca?
Yeah, I would agree. Mm-hmm.
We'll update about the fees, court litigation on that, guys, as we go on. Right now, there is nothing there going on but we'll update on that.
Sudhir from Facebook says that he's on H-1B in the U.S., but his company is unable to file the amendment, I assume because of the government shutdown. It sounds like they are not paying him as a result of that, because they requested that he depart the U.S. And he said he's planning instead to resign and hopefully find a new job within 60 days. Is that the right approach? Yes, it would be, because if you leave the U.S., even if a new company has an offer for you later, it's a whole different situation now. That company would need to file the $100,000 fee if you're outside the U.S. and they're applying for you. So also, this is kind of a situation that could happen to other people also. If you find yourself in a situation where you may not be maintaining status because your company is not paying you for whatever reason, that becomes a more dangerous situation now also. So you don't let yourself go months without payment, because now if you try to file an extension of a transfer or an extension of status or a change of status and you don't have pay stubs for 3 or 4 months, USCIS, if they determine that you were failing to maintain status, even though it's because of the company not paying you, if they deny the change of status or extension of status application, then you don't have any choice but to go outside the U.S. and now the $100,000 fee applies to you. So failure to maintain status is going to be much more dangerous now than it used to be because of this $100,000 fee. So if you are in the situation where the company is not paying you, it is safer to resign, because then you have the 60-day grace period where hopefully you can find a new employer who will file transfer for you. But even if you don't find a new employer right away in the 60 days, you can file a change of status to B2 and be on B2 without pay stubs until you can find a company that is able to file an application for you and pay you.
Kunjal Bomma has an interesting question, and this is what demarcates between whether or not the $100,000 is applicable, though. So the question is that how does the USCIS differentiate when the person is outside the country or inside the country? When we file the H-1B, we ask the USCIS that is it an extension of status? Is it a change of status? Is it an amendment of status? Or is it a consular processing where we are sending it to the consulate, though? So if we are clicking anything other than the consulate, though, then the $100,000 is not applicable. If we are clicking it is the consulate, though, there are with a very limited exceptions, though, where the person might have already have a visa with the company A and now he's applying with this company B, H-1B, with limited exceptions, though, $100,000 is almost 98% of the time it's applicable, though. So whenever we apply within USA, that means we're applying change of status, extension of status, we have to provide them with the I-94. We have to provide them that this person is maintaining legal status. It's a part of the process. Every time any lawyer files a H-1B, when they are in United States filing an extension, amendment, or change of employer or change of status, we have to enclose the I-94. We have to give them this report that this person is maintaining the status. For example, if the H4 person is applying for a change of status from H4 to H1B, we even provide the spouse's H1B approval. We even provide the spouse's pay stubs showing that this H4 is maintaining the status because the person is already married to the H1. Not only that the person is married to the H1B, but that H1B person is already working with a different company and he's getting the pay stubs with that company, though. All the documentation were part of the H-1B way before this $100,000 phase came in. So not an extra work for us. So that simple task that if the person is outside the country, then the antenna of the USCIS way goes up. Whoops, this requires $100,000 fees unless there is a very limited exceptions where the person has already a visa or maybe a national, there is an exception given by the Secretary of Secretary, which either of those things. So that's where the antenna of the USCIS goes when it's a consular processing. When it is a change of status, though, they won't look into the $100,000. They only look into if you maintain the legal status. So that's the demarcation. So very good question, Sunjal. It's a very good question.
Milan from Facebook has a question. It looks like, I don't think the full question got added, but it sounds like their I-94 was only issued to their passport expiration date, which was in August 2025, and they didn't notice until recently. So I think their question was going to be, what are their options now? So because it's less than 6 months at this point, and because there's no travel restrictions, or the fee doesn't apply to H4s, it's only H1Bs. So one option would be to travel outside the country and come back in with your new passport and the H-1B approval that's valid for until 2027 or 2028, and you will get a new I-94 at reentry that should match the H-1B end date. That's probably the quickest way to take care of it, and I think most people go that route. And if you are going to go that route, you need to do it before your I-94 has been expired for 6 months. If it's been more than 6 months, then it's much more dangerous to try to fix it through travel. Probably the only way you can do it is by filing an extension with the nunc-pro-tunc argument, which, like we said, depends on a USCIS officer's discretion. So yeah, try to take care of it as soon as possible now, most likely through travel.
What's the wording, Rebecca, they used if you want to apply for the exemption for the $100,000 fees? But the question is getting asked many times. You said it's extremely rare, or what did they say in the USCIS wording?
Extraordinarily rare. that exceptions will be extraordinarily rare.
Yeah. So there is nothing people are asking if the physicians are exempt. No. The nonprofit organizations exempt are exempt. No. There's nothing particular profession which is exempt, and they're asking. It, it's not about the profession; it's about the particular position, though. A software developer can be exempt, maybe. I mean, it depends on, for example, if this guy is the only guy, and then for the Bank of America, which is one of the biggest bank in the world, and there is a security system, and this guy is from East African country, and this guy is the only guy who can resolve the problems where people can prevent it, then probably, maybe if that guy won the hackathon, where ethical hacking, and he won the entire competition, now he will be the person who is going to test the systems which he needed to test. Probably he could be exempt in those circumstances. I'm assuming they could. But a typical software professional, though, who is just doing a software development may not be eligible for the 100,000 exemption from the $100,000.
Yeah, it definitely looks like they're going to consider it on a case-by-case basis. They have not provided any sort of blanket exceptions for certain industries or certain organizations. So it will be sort of a case-by-case basis, although among the attorneys in our office, we were kind of discussing when this clarification came out yesterday on whether someone with an approved because one of the requirements for criteria is no American worker is available to fill the role. Would having a certified PERM labor certification help, an exception request? Because that's the whole point of the PERM labor certification process is the employer has gone through this long process to try to recruit a U.S. worker and was unable to. So that might be something that could help the argument, although I don't think that alone will be enough. You still have to meet the other criteria.
Rajshekar is asking an interesting question. If somebody has completed 6 years of H-1B, moved back to India, and if they're applying a H-1B, is $100,000 applicable? Absolutely yes, under this one. Now, even if you have an I-140 approval, or even if you are going to the new quota, though, either way, the $100,000 is applicable.
We have a question from someone about concurrent H-1Bs, and do they need to get both the primary and secondary employers stamped when going for visa stamping? So that is sort of an odd feature with concurrent H-1Bs. So if you are in the U.S. in H-1B status, you can have a second employer file a concurrent H-1B for you, and you can work for both companies simultaneously. There's no problem with that. There is kind of a gray area once you decide to travel, because while USCIS can issue an I-797 approval notice for concurrent employment, the consulates cannot issue visa stamps for concurrent employment, and CBP cannot issue I-94s for concurrent employment. So there is kind of an approach. So the conservative approach is that if somebody with a concurrent H-1B approval departs the U.S. and comes back in, there's a way of looking at it where your re-entry into the U.S. with the single I-94, single employer I-94, in a sense, kind of cancels out your concurrent employment approval from before. And so some companies do take the approach of refiling the concurrent application whenever an employee re-enters the U.S. in that situation. Some companies take that approach, some companies don't. And, it kind of, we'll have to see how USCIS treats that going forward. But yeah, there isn't really a way to get the consulates to issue two visa stamps for concurrent employment or CBP to issue a concurrent I-94.
Now, previously, we have told people not to travel outside the country to get the stamping if the H-1B has been filed on or after September 21st. But that clarity is right now cleared. If you already have the H-1B approval with the extension of status, with change of employer, with amendment of the H-1B, even though it was filed after September 21st, since you already got the H-1B approval with the I-94, you can travel. You are eligible for stamping. Does that mean we are encouraging people to travel and get the stamping? No, it just, you cleared one hurdle of $100,000. When you go for stamping, it's like Russian roulette, guys. You know what the Russian roulette is? They put a bullet in the gun and they rotate it. and you put it on your head. Okay, you escaped first time. Then you rotate again, and then you put it again. It's like this. You rotate. You escape from the 100,000. Now you are going again to the stamping, and you want to try your luck there. I don't want you to do that. I definitely don't want you to do it. If you can avoid it, please avoid traveling outside the country, because the consulates now they have an incentive to block you. If they block you, they're going to get $100,000. Because if you don't get the H-1B stamp for that particular H-1B, and then you want to file another H-1B while you're in India, guess what? The $100,000 is applicable. So the consulates have $100,000 extra, 100,000 extra reasons to put you into trouble so that the government can make $100,000. So I definitely want you to be careful.
We have a question from someone asking if an EB2 to EB3 downgrade I-140 petition, do we suggest filing it in premium? So you probably actually cannot file it initially in premium processing, because if you are using a labor certification that was submitted previously in support of an earlier I-140 petition, USCIS usually won't accept premium processing for the downgrade application right away, because they have to go into their original file and pull the labor certification from your old EB2 I-140 file, which was probably from years ago. So what we usually do is file the I-140 downgrade application in regular processing. Once we get the receipt notice, we can start trying to upgrade it. It's not guaranteed that it will be accepted the first time we send in the premium upgrade request. Sometimes we've sent it in 2 or 3 times until USCIS accepts it, because it just depends on how long it takes them to pull the original labor certification from the first I-140 file.
What are the alternative options for the H-1B? O-1 is definitely an option, but if somebody wants to come into United States on F-1, and then later on they convert into H-1B, this $100,000 is not applicable. So definitely, is this a good news for the students in USA, Rebecca? I think so it is.
Yeah.
Because for the people who have been waiting for the H-1B lottery for a lot of years, who have completed their master's degree in United States, this probably is a good news for them. And you want to have a ballet dance there, because the reason is that there will not be much competition. If this stands as it is, there will not be much competition. So most of the H-1Bs will be consumed within the United States. Those people are L1 who have made missing the H-1B lottery. Those people are in H4 who have been missing the lottery. Those people who are F1 who has been missing the lottery. Right now, it probably is a celebration time for them, because you no longer have to, the competition is reduced. It's not that we don't know if the lottery might still be there though, even though you have, even though they block the entire segment of the people coming outside the country. I will think so that it's going to significantly reduce the number of people who are going to come out from outside the country directly in H-1B. But still, we may expect a lottery, but the competition will be very less. So for those people who are in F1, and I'm not supporting what I'm telling, but I'm just telling that it may be celebration time for you.
We have a question from Pavitra asking, does the government shutdown affect the filing of a H-1B cap exempt application? So cap exempt or cap subject are all in the same boat as far as the shutdown goes. You need a certified LCA in order to file the H-1B right now while the government is shut down, whether the petitioner is cap subject or cap exempt.
Hi, Krishna has an interesting question. If he's outside the country and he want to transfer from company A to company B, is the $100,000 fees applicable? Assuming you don't have a stamp already with valid stamping on H-1B, absolutely $100,000 is applicable since you're outside the country. And what about if I'm outside the country and I'm filing for a H-1B extension? Is the $100,000 applicable? Yes, it is applicable if you are outside the country.
We have a question from someone who, with their I-485, it was initially submitted in 2020 in EB3, transferred the underlying basis to EB2 in 2022. I don't see I think they submitted their question in different pieces, so I don't see the end of their question, but I assume their question is what can they do now if their priority date is current in EB3? If you are with the same I-140 petitioner, or if the original I-140 petitioner is willing to, they can still file another J supplement to transfer the underlying basis from EB2 back to EB3. You can only do that if the priority date is current according to the final action dates chart. So make sure you're looking at chart A in the visa bulletin, not chart B. Once it's current in chart A, then the I-140 petitioner can submit that J supplement requesting a transfer of the underlying basis again. So it does require the original I-140 petitioner's willingness to file that J supplement, either because you're still working for them or because they never withdrew any of the I-140s and you still have a relationship with them. They still have that job offer available for you. If those I-140s were withdrawn or you no longer have, that job offer from the original I-140 petitioner, it's not possible, unfortunately, to have the underlying basis transferred by a new employer, even though you can work for the new employer based on AC-21 because of the job being same or similar. So those are kind of two different concepts under the I-485. Just because you're working with a new company in a same or similar position, that company cannot transfer the underlying basis of your I-485. If that's the case, then you will just need to wait for your priority date to become current under EB2.
Question coming from Khammam Girl. That's very near to my village. Even though I'm from Warangal, my village is near to Khammam. She's asking the question, is it feasible for the people to convert from B2 to H-1B without the 100,000? The same question is coming from Mr. Shah from X. Practically, it's not viable to change from B2 to H-1B. The reason is that the lottery process starts in March. So if you apply in March, so B2 is like only for 6 months. So if you apply in March, then are you inside the country or outside the country? That's one thing. If you're inside the country, your B2 expires by October 1st, which is when your H-1B starts. There's also that if you're traveling into United States with the purpose of applying for the H-1B though, then that's a violation because you had the intent to, it's called preconceived intent. When you're entering into United States, you should have only to intention to follow through on the visa for which you are visiting. So if you're coming on a visiting visa, then your purpose is only to visit and get outside the country. Your purpose should not be to change the status. Now, if you change your intention after you come into United States, the question will come at after how long have you changed the intention? Did you change immediately? Did you change afterwards? If it's changed within 90 days, they may presume that you had the intent, that you came on you came on B2 and then you applied the change of status within 90 days. They may presume that you had the intent and you conceive that intent. That's called preconceived intent, and they may deny the change of status totally because of that reason. So definitely there are some problems with it. We don't advise people coming on B2 with an intention of applying the H-1B. We don't recommend. Now, can people come on H-4 though with an intention of changing to H-1B later on? Absolutely, they can. There is an exemption because H4 and L2s, L1s, they're exempt from this. They're called dual intent visas. L2s, L1s, H4s, they are dual intent. So they can come with an intention. They can come on L1 with an intention of, oh, I'm going to change to H1B once I come into the United States. They can do it. Can L2 people do it? Absolutely, they can. H4 people can do it. Yes, they can. The B2 people cannot do it. Now, F1 people have some restrictions, but since if they are already here for a long period of time, they stayed in United States, then they change their intention because F1 is for a long duration. B2 is only for 6 months. So for F1 people, it may be practical for them. Once they come into United States, they can change their intention and file the H-1B. For B2, it is B1, B2 people, it's very impractical to come on a B1, B2 and then change to H-1B.
Avinash is asking, given all this information, is it safe for an H-1B visa holder to travel outside the U.S. with a valid visa if the H-1B visa is stamped and valid until 2027, for example? Technically, you can, because you don't have to go to the consulate to get a new visa. If you have the existing visa and an approved I-797 approval notice, you can use that to travel. However, we are still advising caution on all international travel because, even though this fee proclamation doesn't apply to you right now, we don't know what else the government is going to announce or roll out that could be broader and affect more work visa holders. When this was announced, it went into effect barely like 30 hours after they first announced it. At that time, it was still very unclear who and what it applied to. And so there were people outside the US at the time that were scrambling to get flights back into the US. And not everyone could with enough time. And so if this fee proclamation gets upheld in court, for example, it could give the administration ideas of other categories or broader categories to announce some sort of proclamation against. Like we said earlier, the government's authority is broadest to individuals who are outside the US. And so even though this particular proclamation may not apply to you, who knows what else they have planned to announce that could apply to you. And if you're outside the US at that time and can't get back in before something becomes effective, it could still be a bad situation. So we're still advising caution for any international travel, even with a valid visa.
Interesting follow-up question from Shah. But for those adjusting B2 while laid off in US, doesn't the same issue arise when going back to H-1B? Two reasons it's not, Mr. Shah. But very interesting question what you brought in, though. One reason is that when you're applying for B2, we may be indicating that we are going to apply for the change of status back to H-1B, because USCIS website, even though it's archived, though, they did recommend it to change the status to H-1B, and then you can do premium processing change the status from H-1B to B2 if you lose the job, and they can change back it to H-1B in premium processing. They recommended that. So for that reason, that what I told you about changing the status to directly come from India with a new quota, there may be a problem. But in this case, there may not be a problem. There's other reason is that new quota people have to wait for October 1st. If somebody is changing the status within United States from H-1B to B2 and they want to convert back into H-1B, though, they don't have to go through the quota. There is no 6 months limit for them. So that time limit is more flexible for the people who have already been on H-1B. For these two reasons, your statement may not be applicable correctly, though.
Vikram previously was on H-4 EAD, moved to H-1B, but is looking to convert back to H-4 now. Because he was laid off, and is asking, can he use his old EAD or does he need to apply for a new EAD? If you're filing the I-539, I would go ahead and file the I-765 along with it. But if for some reason your I-539 gets approved, your status gets changed to H-4, and there's some delay in the new EAD being issued to you, I would say you can start working probably using the previous EAD as long as it is unexpired at the time. So that previous EAD can still be used once you move back into H-4 status. You can't use it before that, but once your I-539 application is approved and you are back in H-4 status, you can use that C-26 EAD for work authorization. I would still apply for another I-765 along with it, though, because it's easy to do so and it doesn't take too long.
Is extension of H-1B with the same company is impacted by the shutdown? Yes, because you need an LCA for the extension of the H-1B. It is impacted. So if somebody's H-1B is expiring, in the month of October or in the month of November, they probably need to have a plan B to have file a B2 filing if by any chance the H-1B extension cannot be filed before the government shutdown.
We have a question of how long are PERM application approvals taking. Prior to the shutdown, it was about 15 to 16 months, I believe. Of course, right now, while the government is shut down, DOL isn't processing any PERM applications. So we will have to see once the government resumes operations if this shutdown affects processing times. My guess is it will, and that they will be even longer than they were just before the shutdown somehow.
Questions are coming with regards to the people who have already applied the H-1B and they're going for stamping right now. Here, if they are outside the country. Now, first thing is that if the H-1B has been filed before September 21st, even though it might have been approved after September 21st of 2025, the $100,000 is not applicable.
Yeah, basically, I think if you have an I-797 approval notice in your hand right now, you can go for visa stamping. We're not recommending that you do, but if you need to, you can without the fee being applicable to you. Again, it looks like the government is putting the burden of assessing who the fee applies to on USCIS, not the consulates or CBP.
Does the shutdown impact the I-140? No, I-140 is more fees driven. The USCIS is fees driven. It's not impacting the I-140 application at this point of time. People can still do premium processing if they want to. They can go the normal processing. We haven't seen a significant delays in the I-140s right now.
We have a question of, can we file a concurrent petition to self-sponsor an H-1B based on the January 2025 regulation? So the January 2025 H-1B regulation allowed for H-1B beneficiaries to be majority owners of the petitioning organization. And so it's kind of the entrepreneur H-1B. So we have filed several of those already this year. They've gone through pretty smoothly. You do still need to be able to pay yourself the prevailing wage. You know, you still have to file the LCA. There's still the LCA requirement there, and you need to be able to pay yourself the LCA salary. So depending on what stage the company is in, either you need to prepare to have enough invested upfront to pay yourself your salary from that, or wait until the company is in a position that has where it's generating revenue to be able to do that. But like this person was suggesting, you can do it as a concurrent part-time H-1B. That is one of the ways that we have filed these, which reduces some of the burden of paying like a full-time prevailing wage from a brand new company. So you can maintain your full-time H-1B employment with your current employer and then start your business concurrently part-time through that H-1B.
Many questions on the many questions are coming with regards to the 100K fees, guys. I'm going to put a frequently asked question, and Rebecca has already put an article on our rnlawgroup.com. But based on the questions that you're facing, I will put a FAQs. I will publish it by tomorrow, so you can look into it, and on those things, I will answer all those questions in that FAQs, guys. And you can subscribe to RN Law Group. There's a blog there. You can subscribe to it, so you'll get any of the new things from there. Anything else, Rebecca, before we close?
No.
Thank you very much for guys for tuning in. We do have a daily conference call where you can have a free conference call that we are conducting from past 13 years. The link is provided there. You can come there and ask questions. It'll be live interaction for you there. Please subscribe to our channel for any news